When filing a revision petition, what is generally in the mind of the petitioner? That revision is maintainable when there is no right of appeal, when there is any jurisdictional error or material irregularity exercised by the court below. But a very important point which I want to make today, that revisional jurisdiction is far, far more narrower than it seems to be. In fact, it is so much restricted that I will show today that how the respondents in revision can easily demonstrate before the court that the revision is not maintainable in most of the cases. The relevant provision which I am talking today is the Proviso to subsection 1, section 115 of Code of Civil Procedure, that is revision. Now the Proviso says that the revision is maintainable and the High Court can reverse or vary the order which is being challenged in the revision only if the order, if decided in favor of the petitioner, then that order would have finally disposed of the suit or proceedings. The catch here is the word if. In easier sense, please try to understand, for example, there is an order of the lower court which is being challenged in the revision before High Court. The order is being challenged by the petitioner because it is against him, but this proviso says if that order would have been passed in favor of the petitioner by the court below, then if it would have been disposed of the suit finally, only then the revision is maintainable, otherwise not. Now to understand the essence of this provision, of this proviso, we will take the help of a Supreme Court ruling. Shiv Shakti Cooperative Society versus Swaraj developers and others. However, this Supreme Court ruling provides clarity, but we will take instead the help of a Bombay High Court ruling because it is more illustrative. The name of the Bombay High Court ruling is Chandu, son of Jagannath Ambedkar versus Digambar, son of Kishan Rao. This ruling is very famous and the fact of the case will help you to understand this proviso better. So in this case, the petitioner originally filed a civil suit before a civil judge. That suit got dismissed on default. So to restore that suit, a restoration application was made by the petitioner. But that restoration application was made after the limitation period. So effectively it was barred by limitation. So the restoration application was accompanied by a condonation of delay application also. Now that condonation of delay application was rejected by the court. So again, against that order of rejection of condonation of delay, the revision was made by the petitioner before the High Court. So long story short, there is a condonation of delay application. This condonation of delay application was rejected. So against this rejection, the revision was made in the High Court. This is the fact. So High Court made a very important issue. One of the issue was that whether the revision petition against the order rejecting the condonation of delay application is maintainable or not. So I will tell you the first what was the judgment of the court. The court ultimately held that such revisions are not maintainable. But why? This was the judgment. But the reasoning is much more important because you will understand if this is not maintainable, then most of the revision petitions against any of the order is not maintainable. So in this case, what court explained, what was the reasoning? The petitioner came against the order rejecting the condonation of delay. If the court below would have allowed the condonation of delay, then what would have been the effect? The effect would be the restoration application would further initiate and would be heard on merits. So that condonation of delay, along the condonation of delay, would not have finally disposed of the suit or proceeding before the court below. That is why the revision is not maintainable. But this is not true for vice versa condition. Because we will take another circumstance. For example, a court condoned the delay. In that case, the revision is maintainable against that order of condoning the delay. Because if the court would not have condoned the delay, then what is the effect? That the suit will be dismissed for being time barred. It will not be heard further. So what is the effect? It will be disposed of finally. Therefore, the condition is met and the revision will be maintainable. This is the logic of this provision. Further, the Supreme Court ruling which I stated earlier, the Shiv Shakti one, had stated that revision is not maintainable against any interim order. It is maintainable only against final orders. And it is the basic concept of revision that the revision can be made against the final order and not any interim order. But the point I want to make today is that revision is not even maintainable against all final orders. The petitioner has to satisfy that the order against which he has made the revision is a final order, and also if that order would have been come otherwise, that is in favor of the petitioner, then also it would have finally disposed of the suit or proceeding in the court below. Both the essentials have to be fulfilled, only then the revision is maintainable, otherwise not. And apart this, there are other essentials also, that revision is maintainable only if the appeal is not maintainable, number one. Then there should be material irregularity. Then there should be any jurisdictional error in the court below. So after applying all these essentials, only then the revision is maintainable. Now, do you know that this section which we are talking today, section 115 of CPC revision, is a very disputable and disputed provision, because once the Law Commission wanted to delete this provision from the CPC, because it was of the opinion that there is already an article 227 in Constitution which gives the supervisory power to High Court over and above all the lower courts, the courts below. So this article in effect fulfilled all the concerns that section 115 of CPC tried to handle. So what is the need of another provision? However, the Joint Parliamentary Committee was against the opinion of complete deletion of this provision. Rather, it added a proviso, which we talked about today in this video, which became effective from the date 1 July 2002, that even being final order, the order, if it would have decided in the favor of the person applying for the revision, would have finally disposed of the suit. So in the end, I want to know whether you find this topic of revision complicated. If yes, then please consider that why the cases are pending for so much long period of time in the courts below. Because the law is very much complicated. But if you have understood this concept, first of all, I want to appreciate you. Secondly, I want to ask that in your opinion, whether this provision 115 of CPC should remain as a provision of CPC, or it should be deleted and High Court should rely only on the writ jurisdiction as given under the Constitution of India. I shall wait for your opinion in the comment box.